Yes, the Biden administration did take steps to provide significant relief to Black and minority farmers through the American Rescue Plan Act of 2021. This act included a provision for $4 billion in debt relief for socially disadvantaged farmers and ranchers, which encompasses Black, Hispanic, Native American, and Asian American farmers. This measure aimed to address long-standing disparities in the agricultural sector, where minority farmers have historically faced discrimination in accessing loans and other financial assistance from the USDA. Background on the relief measure. The $4 billion was intended to cover up to 120% of the outstanding debt of these farmers and ranchers, helping to offset the economic hardships they have endured, partly due to systemic discrimination and partly due to the pandemic. This relief was seen as a critical step towards rectifying some of the historical injustices faced by minority farmers. Legal challenges and delays. However, the implementation of this relief has been delayed due to legal challenges. Several lawsuits were filed, arguing that the debt relief provision was discriminatory against white farmers. These lawsuits resulted in injunctions, effectively halting the distribution of the funds. The court's decisions have centered around the argument that providing debt relief based on race constitutes reverse discrimination, which violates the Equal Protection Clause of the U.S. Constitution. Outcome and current status. As a result of these legal challenges, the debt relief funds have not been dispersed to the intended recipients. The Biden administration has faced criticism from both the farmers expecting the relief and those who oppose the measure. In response, the administration and Congress have sought to revise the program to address the legal concerns while still providing the intended support. This led to the passage of the Inflation Reduction Act in 2022, which replaced the race-based debt relief with a broader relief program that does not explicitly prioritize any racial group but focuses on farmers in financial distress. This shift was an attempt to make the program legally defensible while still offering relief. However, this change has caused frustration among many Black and minority farmers who felt that the original intent of the program, to address specific racial inequities, was being diluted. Why no action yet? The primary reason for the delay in providing relief has been the legal battles that arose from the original structure of the debt relief program. The court's injunctions prevented the USDA from moving forward with the debt cancellations, and the legal process has been slow. Additionally, the restructuring of the program to comply with legal standards has taken time, contributing to the delay in delivering the promised relief. In summary, while the Biden administration did sign a $4 billion relief package for Black and minority farmers, its implementation has been delayed due to legal challenges. The situation highlights the complexities involved in addressing historical inequities within the framework of current legal standards. Several lawsuits were filed in opposition to the American Rescue Plan Act of 2021, particularly targeting the provision that offered debt relief to socially disadvantaged farmers based on race. These lawsuits generally argued that the provision was discriminatory against white farmers and violated the Equal Protection Clause of the U.S. Constitution. Number of cases filed. As of the latest available information, at least 12 federal lawsuits were filed challenging the debt relief provision under the American Rescue Plan Act. These lawsuits were filed across various states, including Texas, Florida, Tennessee, Wisconsin, and others. Key cases. 1. Wynn v. Vilsack, Texas, one of the first major lawsuits filed by Sid Miller, Texas Agriculture Commissioner, on behalf of white farmers. 2. McKinney v. Vilsack, Tennessee, a group of farmers from Tennessee challenged the provision. 3. Joyner v. Vilsack, Florida. White farmers in Florida argued the debt relief provision was unconstitutional. 4. Fava v. Vilsack, Wisconsin. A lawsuit was filed by a group representing white farmers in Wisconsin. Court decisions and injunctions. In several of these cases, federal judges issued preliminary injunctions that halted the implementation of the debt relief program. These injunctions were based on the argument that the race-based criteria likely violated the Equal Protection Clause, effectively pausing the program nationwide. Outcome. These lawsuits significantly delayed the disbursement of the funds intended to provide relief to minority farmers. The legal challenges eventually led to the Biden administration and Congress reworking the program under the Inflation Reduction Act of 2022, which removed the race specific provisions to comply with court rulings. In summary, there have been at least 12 significant lawsuits filed across various states, which have played a key role in preventing the immediate implementation of the debt relief measures originally intended for socially disadvantaged farmers under the American Rescue Plan Act of 2021.